Good evening. My name is Jehan El-Jourbagy, and it's my privilege to welcome you to the Supreme Court Review here at Georgia College. I'm an assistant professor of business law and ethics, and I also serve as the chair of Georgia College's campus-wide Constitution Week committee. This evening, we're going to cover basics of the most recent terms, some facts and figures. We're going to talk about the composition of the court. We're going to hear about an electoral college case, a landmark employment rights case, as well as a case regarding DACA and other immigration law cases. At any point this evening, you may ask a question of one of the panelists using the Q&A function. You're going to see that at the bottom right of your screen. Now, Dr. Elliott-Gower here at Georgia College is going to be the person to facilitate Q&A. So when you ask those questions, Dr. Elliott-Gower will actually ask those questions of the panelists on behalf of you as the attendee. We appreciate you being here this evening, and hold on to your laptops. We're going to go ahead and dive into the most recent term here. So in October, the most recent term, we had just 53 signed merit opinions. That is the fewest merit opinions. We have to go all the way back to the Civil War, 1862, to see fewer opinions issued in a term. There were 2 per curiam merit opinions. And per curiam means by the court. It essentially means it's an opinion of the court that does not have an author assigned to it, or a justice who is designated as the author. There were 6 summary reversals, and unusually, there were 10 arguments in May. Now, this was unusual because the court closed due to the pandemic. And the last time we saw the court close, or we didn't see it, but the last time that the court closed was back in 1919 during a pandemic at that time. We have a speaker here this evening who actually had to engage in telephone arguments, and another speaker this evening who's at the table in person. I'm going to share with you some data from SCOTUS blog, which is a great resource for everything Supreme Court. This tells you where cases came from, where they, how they got to the United States Supreme Court. So you can see both the Ninth Circuit and the state court had the most cases that went to the Supreme Court. This shows you that of the 9 justices, who wrote the most opinions. And you can see here, Justice Thomas authored 31 of the opinions. He also wrote the longest opinions, or the most lengthy. So 26 of those 31 opinions were 5 pages or more. So you can see here that he was verbose in writing, at least, and also had some of the most lengthy opinions. This chart shows you opinions over time. And so in the last 15 years, if you look at the blue bar at the bottom, in this most recent term, we have the fewest. And as I mentioned before, it was back in 1862 that the last time we can see fewer cases issued by the court. Now, I know there's a lot of information on the screen now. It's basically referring to the justices and how often they ask questions. Which justice asked the most first questions? Who were the top 3 questioners? And at the bottom, I've put an arrow to show you that this does not cover the cases that were covered in May. So the telephone cases, not part of this data. So up here at the top left, Sotomayor actually had the most questions per argument. And then I circled Justice Ginsburg, who was the most often the first questioner. So she was first out of the gate with a question for the litigants. Now going to May, the format changed. It was over the telephone. Chief Justice was sort of master of ceremonies. Questions were asked in order of seniority. And in this case, let me go back to the slide. If you look at the middle top box, it shows Thomas with no questions. Top left, no questions from Thomas. This is his practice. He has historically had 0 questions. But here we go to this telephone format, and now we can see at the bottom, he did actually ask questions in that telephone format. So he used some of the time to ask questions during the oral arguments. And finally, this slide shows you justice agreement. So of the 9 justices, which justices had the most agreement? And Ginsburg and Breyer at 90% total agreement. Then over here, you're going to see, I'm going to slide Professor Lessig out of the way there. Chief Justice Roberts and Kavanaugh also had a high degree of agreement. But the most disagreement, that was between Justice Thomas, who is from Georgia, the Savannah area, and Justice Sotomayor. So overview in terms of agreement, 36% of cases were unanimous. In the last 2 terms, 39%. So it's a little bit less in regards to unanimous cases. 30% were 8-1 or 7-2. So you can see, I mean, 66%, we had a large majority of justices in agreement. 23% of the cases in the last term were 5-4, and those are the cases that often make headlines and are over some really sometimes contentious or current event cases. And so I'm going to stop sharing my screen for a minute, and I'm going to give everyone an opportunity to see where you are in terms of, it says that I'm stop sharing. Sure, I'll go over here. Bear with me for a moment. All right, so I'm going to open up a poll, and on your screen, you're going to see about 7 questions, and you will have just 2 minutes to provide your answers. So if you will go through these questions, again, you have 2 minutes, and panelists, you're welcome to answer these questions if you like as well. First question being, assuming every seat is filled, how many justices serve on the Supreme Court? Kind of get some benchmark data on what our audience this evening. We have 123 participants so far. Number 2 asks you, how many cases did the Supreme Court decide in 2019? See if you were listening. To become a Supreme Court justice, just get some data on that. Which Supreme Court justice authored the most opinions? How many justices serve, assuming that every seat is filled? The name of the Chief Justice. And then finally, what prompted you to attend? You have 58 seconds remaining. Just 30 seconds. You are just now attending. We are completing a poll to see what you know here. When we do this live, we usually do a Kahoot poll. This is the first time for us online. Ten seconds. All right, that concludes the poll. Our first distinguished panelist this evening is Matt Roessing. He's a lecturer in legal studies at UGA's Terry College of Business, where he teaches the legal aspects of business, real estate, and international trade. Professor Roessing previously taught business law at Georgia College and started the very first Constitution Week Supreme Court review here at Georgia College. Before his teaching career, he worked in the Washington, D.C. office of Arnold and Porter, LLP, and he now runs his own law firm in Milledgeville, where he represents local business owners and serves on the board of the Chamber of Commerce. Oh, let me go ahead.
Sorry.
That's all right. Okay.
Kline.
Oh, let me go. Oh, he's muted now. All right. A national award-winning instructor. We're back to Matt Roessing. His work on the scholarship of teaching and learning has appeared in the Journal of Legal Studies Education, the Journal of Legal Studies and Business Education Innovation Journal. An avid Supreme Court watcher, Professor Roessing has discussed its decisions on Georgia Public Broadcasting, Macon's Law Call, and Georgia College's WRGC. Professor Roessing holds a bachelor's in English from Williams College and a JD from the College of William and Mary, where he was articles editor for the Bill of Rights Journal. Professor Roessing.
Thank you very much, Jehan, and thank you, Steve, and thanks once again for hosting this great event with these wonderful panelists. My topic for tonight was Chief Justice John Roberts, but I thought we'd be remiss if we didn't take at least a few minutes to discuss the passing of Justice Ruth Bader Ginsburg and the legacy she leaves for the court. So I'm going to take a few minutes to talk about that before I transition into talking about the Chief Justice and his evolving role on the court. Justice Ginsburg, she sat on the Supreme Court for 27 years, and her influence on the court and the law is immeasurable. You're going to hear much more touching, tributes and more informed than tributes than mine over the next few days. But I'm at least going to give a little bit of a try to help students understand how important she was not just in women's rights and equality of the sexes, but also, her influence, on the court throughout the Roberts period. Now, just a simple way to look at her influence is to look at her law clerks. She had over 100 law clerks during her time on the Supreme Court. And in fact, today she's lying in state in the Supreme Court, and her law courts, so these clerks, at least many of them, stood on the steps to receive her as she came in. Very touching tribute, and also just a great visual metaphor for the impact that she has had and will continue to have. These law clerks are among the smartest law students in the nation that forego their legal careers for a year or so to intern with great judges and justices. So we can expect that Ginsburg clerks have and continue to serve in the highest levels of government, law, as well as academia. She didn't join the court as a justice until 1993, but even before that, she was having an influence on the court as a lawyer. She appeared there 6 times during the 1970s while she was a professor at Columbia. And she appeared arguing cases for the ACLU's Women's Rights Initiative, which she co-founded. And a lot of these cases involve the question of whether the rights to equal protection, which are found in the 14th Amendment and the Due Process Clause of the 5th Amendment, also cover sex discrimination, and to what degree they are covered. And oral arguments are audio recorded, so you can actually listen to audio recordings of the oral arguments. I was pleased to get to listen to Professor Lessig's argument a few days ago. And one thing I noticed as I was doing that is that even these arguments back to the 1970s have been recorded and are now available online. So I was listening to some arguments made by then lawyer Ruth Bader Ginsburg before the Supreme Court. And I encourage you all to do that. She's obviously an amazing advocate and was even then. Very clever the way a lot of these cases were brought. She really moved the needle of case law to get recognition of gender equality and to have sex discrimination treated as a 14th and 5th Amendment issue. And did it in kind of a clever way in that she was making arguments to, at the Supreme Court, all male judges, and on the way to the Supreme Court, primarily male judges. A lot of the cases the ACLU chose to bring were actually cases where men had been discriminated against, or where benefits were being provided to widows of people in the military, or Social Security benefits that were being given to the surviving spouses of men. But yet those same benefits were not being given to men whose female spouses served in the military or died, and leaving the men with childcare duties. So, this is a technique that we've seen often by the ACLU. They pick a case that they think will speak to the justices. And of course, as they're knocking down these barriers for men, getting a ruling that is at least nominally in favor of men, what they're really doing is undoing sex stereotypes. All of these discriminations were based upon the theory that men are the breadwinner, men are fighting in the military, where the women are at home. So by getting the court to rule for men, she was, really getting rulings for women. And then as she joined the Supreme Court, we saw some of the arguments that she had advanced to serve as precedents for opinions that she delivered as a Supreme Court justice. One of the very notable ones was U.S. versus Virginia, which dealt with the all-male enrollment policy at Virginia Military Institute. So only men could join that institute. They tried to set up a separate institute, for women. But it was found that this, and she wrote the majority opinion, and it was found that that was unconstitutional sex discrimination. It was a 7-1 opinion, so it wasn't even close. And I think that, her influence as a lawyer was plain in that final Supreme Court opinion that she delivered. In recent years, she was often in the dissent on close cases. As I'll mention later, we've had a very polarized Supreme Court by political ideology. And we often saw the court's conservative wing pitted against its liberal wing, with her, being on the liberal side. However, she continued to have great influence as a dissenter. And since 2010, she was the most senior member of the court's liberal wing, and I think even acted as a sort of chief justice of the minority party in a sense. Deciding who was going to write dissenting opinions, and very likely behind the scenes working with the justices that would join her opinions to make sure they had a cohesive, solid dissent and one that they could all join. So one thing that people that study the court have noted in recent years is that this block of Ginsburg, Kagan, Sotomayor, and Breyer, who's traditionally seen as the court's liberal wing or liberal minority, when they dissent, they do it in one dissenting opinion. It's rare that they fracture into multiple dissents, whereas the conservative majority, even though they all agree on the outcome of the case, they don't tend to agree on the reasoning all the time, and we see a bunch of concurring opinions. So, it's thought that even though the dissent does not serve as precedent, the idea of a powerful, unified dissent versus a fractured majority may have increased the standing and the way these opinions are viewed by posterity. Another thing that's worth noting is her friendship with Justice Scalia, who passed away in early 2016. They often took opposite sides on divisive social issues, and they would trade barbs in their opinions. If he was in the majority and she was in the dissenting, they would often even write back and specifically talk to each other in those opinions. On the other hand, they were great friends. And they were both opera fans. They would both attend performances together. I think even at one point they were extras together in an opera. And then there's actually an opera that was written about them called Ginsburg Scalia, where their historic battles on the court are seen in operatic fashion. They were on a panel in 2015 where they talked about this friendship, and Scalia, they really showed their wit in this as well. Scalia said about her, what's not to like, other than her views on the law, of course. And she said about him, I disagreed with pretty much everything he said, but I loved the way he said it. So I think that's a great example for all of us, and also a sad irony that the death of each of these justices has set off vicious partisan battles over their replacement. I'll turn now to Chief Justice John Roberts. That was not the right answer, right? So I got that one right. So its Chief Justice is John Roberts. And I'll lead off with another great irony, that this man who seems to have made it his mission to preserve the Supreme Court as an institution and avoid a perception of the court as partisan, he may end up deciding the 2020 presidential election, or at least casting a very significant vote, and what will likely be seen as a partisan outcome if it goes to the court, which it might. This Roberts Court, we typically name the court after the person who is Chief Justice at the time. So the Roberts Court began in 2005, and it was already divided along partisan lines. So that's really been a hallmark of his tenure as Chief Justice. Roughly split between justices appointed by Democrat presidents and Republican presidents, with the exception of Justice Souter, who was appointed by a Republican president, but drifted left as the years went on. However, until very recently, all eyes were not on Roberts, but on Anthony Kennedy. So Kennedy, this conservative justice who would occasionally, and maybe even more than occasionally, join with the four liberals on the court and became known as the swing vote. Although he didn't like that, he said, the cases swing, I don't. But he was willing to go back and forth, and therefore everyone was paying attention to him. All the arguments were made to him, citing his opinions and doing things that were favorable to him. He was the vote to get. And Roberts was, somewhat ignored, although there were occasions where Roberts would swing, most notably in a series of cases challenging the constitutionality of Obamacare. And that's pretty significant because we have another Obamacare case coming up in the next term. Most notably in 2012, he cast a swing vote to say that Obamacare's individual mandate, the rule that everyone has to buy health insurance, he preserved that. He was largely expected to knock it down and say that's unconstitutional, but he said it was, although he called it a tax rather than the government's preferred explanation that it was justified under the Interstate Commerce Clause. And however, with the departure of Kennedy, Roberts has really become a central figure on the court. I wouldn't really say he's a swing vote, but he has swung in a few very key decisions, including in this term. And likely, at least what it looks like, is when he does swing, it's when he feels that the court's reputation is at stake. Notably, last year, he denied the Trump administration's request to put a question regarding citizenship on the US Census. And he kind of said, I would have been okay with you doing this had you gone through the right channels, but it looks like you're just trying to get me to rubber stamp this without following, the things that the Administrative Procedures Act requires. So he didn't go along with it. Just this term, he refused to overturn a recent precedent on abortion, even though he had been in the dissent when that precedent was established. So going against his principles and the way he thought the case should have been decided to preserve stare decisis. And then most recently, he ruled against the president's assertion of absolute immunity in a subpoena for the president's, or at least the Trump organization's, financial and tax records. So the main theme of the Roberts Court seems to be that he is an institutionalist. He wants to preserve the integrity of the Supreme Court. Despite the past few years doing this in very trying times, he took a rare step of responding to President Trump's comments when President Trump was complaining about a judge that ruled against him and said, "Oh, that Obama judge, ruled against me." And Roberts came out in public and said, "We don't have Obama judges or Trump judges. We just have people doing their best." I'm paraphrasing. He also, presided over President Trump's impeachment trial. So talk about really being thrown into the partisan fire. Still, he really seems to have navigated this middle road, and he commands great respect from, in particular, Gorsuch, Kavanaugh, and even Kagan, bringing them along with him on some key opinions. In fact, I was going to say before Friday that I think the Roberts Court is just beginning. And that he may have an opportunity to mold the court in his image for the next decade or more. Although now, with the death of Justice Ginsburg and what is to follow, I wonder whether the Roberts Court is over. Because this choice of the next Supreme Court justice is descending into partisan division. We see a bitter confirmation battle on the horizon. He may end up being a critical swing vote in what may end up being Bush v. Gore 2020. But after that, he's either going to preside over a solidly conservative court where his vote won't matter so much and he'll have less influence, or maybe if it could even end up in a Democrat court packing scenario where he gets outflanked on the left. So either way, it's very hard to see how the Supreme Court keeps this nonpartisan reputation that he has striven to maintain. And with that cheerful thought, I will turn things over to my fellow panelists.
Thank you, Matt. I appreciate you providing a summary of Justice Ginsburg's distinguished career and also discussing the Roberts Court. Our next panelist this evening is Lawrence Lessig. He's the Roy L. Furman Professor of Law and Leadership at Harvard Law School. Prior to returning to Harvard, he taught at Stanford Law School. And actually, if you caught our panelist or our keynote lecture on Thursday, Fred Smith, he actually took Lessig's class at Stanford. When he was at Stanford, he founded the Center for Internet and Society and at the University of Chicago. He clerked for Judge Richard Posner of the Seventh Circuit Court of Appeals and Justice Scalia on the United States Supreme Court. Professor Lessig is the founder of Equal Rights, a founding member of Creative Commons, founder of the anti-government corruption organization Root Strikers, and a former director of Harvard University's Edmund J. Safra Center for Ethics. His most recent books include They Don't Represent Us, Reclaiming Our Democracy, Fidelity and Constraint, How the Supreme Court Has Read the American Constitution, and America Compromised. Professor Lessig holds a bachelor's in economics and bachelor's in science in management from the University of Pennsylvania, and a master's in philosophy from Cambridge University, and a Juris Doctorate from Yale. Ladies and gentlemen, Professor Lessig.
Thank you, and thank you so much for inviting me to participate in this. I'm going to talk about the case Chafalo versus the state of Washington, which is a case involving the freedom of electors, the constitutional freedom of electors to vote their conscience in the context of casting a vote for president. But before I do that, I just want to set up the context of that case, because of course that context was fundamental to how the case was actually decided. You mentioned I published a book last year called Fidelity and Constraint. And what Fidelity and Constraint tried to argue was that there was a tension that the court often had to live through between, on the one hand, the faithful reading of the Constitution, and the other hand, the constraints the court found themselves faced with, given the political context of the time or the pressures that the court was living under. And the book is an account of how they navigate that constraint, how they try to maintain fidelity to the meaning of the Constitution subject to that constraint. Now, when I argued this case from my telephone, sitting in my office at the Harvard Law School, and literally my telephone, it wasn't even Skype or what we're using, WebEx, it was a telephone, right? I felt in a certain sense that the paradigm of my book had trapped me in this case. Because going into this case, the amicus briefs that we were facing had set up this terror in the context of the court about what would happen if electors were deemed to be free to vote their conscience. And one amicus brief had suggested that they could be bribed and that there was no regulation limiting their ability to be bribed. And for most of the oral argument, the focus of the justices was on the quote unquote chaos that would reign if in fact electors were free. And of course, in the context of an oral argument, not to mention an oral argument by telephone where you can't even look somebody in the face as you're trying to engage in an argument, it's a challenging moment to try to flip the presumption that this reality would be chaos. But it is the reality that for the whole of American history, the presumption had been that electors had a discretion, just like a member of the United States Senate has a discretion. And that discretion is constrained, of course, by their political allegiances or by what they say they're trying to accomplish. But that constraint is never absolute, and that constraint is never enforceable legally. And so in the context of a United States senator, take, for example, John McCain, when he was called upon to cast a vote about whether the Obamacare would be repealed or not, he surprised everybody by voting not to repeal Obamacare. He surprised everybody in the sense that everybody expected him to vote one way and he voted another way, but nobody would have said that anybody had the power to constrain how John McCain voted, because to have the power as a senator is to have the power to cast a vote. And that was the core question that existed in our case. So in our case, Article 2 of the Constitution says that, of course, the president is not chosen by the popular vote. He's chosen by electors who vote in the Electoral College, actually in electoral colleges around the country. And electors have a very special meaning in our Constitution. Article 2 speaks of presidential electors. Article 1 speaks of what Justice Thomas has called congressional electors. Article 1 says that congressional electors will be used to select members of Congress. By that, they mean voters. And voters, of course, we all understand, have a constitutional discretion to exercise their vote as they see fit. And so that conception of electors, we argued, was the same conception that the framers had when the framers said that electors will cast their vote for president. And indeed, that conception caused a lot of trouble early on in the history of the Republic. The very first contested presidential election, which happened in 1796, was an election where in the state of Pennsylvania, there was an elector who was presumptively picked to vote for John Adams. And that elector realized after he was selected that in fact the state had voted overwhelmingly for Thomas Jefferson. So though he was selected to vote for John Adams, that was not actually what the people of Pennsylvania wanted the president to be. So he cast his vote for Thomas Jefferson. He was a faithless elector. And when he did that, everybody said it's outrageous that he would vote contrary to how he was pledged and that he should not have done that. That was not what he was asked to do when he was asked to be an elector. But nobody doubted he had the power to do that. And indeed, when the 12th Amendment was being debated, the fact that electors had this power was a question people raised. Indeed, Thomas Jefferson himself suggested that maybe the 12th Amendment should include a provision that banned electors from voting as electors, instead just allocated votes to states to avoid exactly this kind of discretion. And throughout the whole of the 19th century, Congress again and again and again proposed amendments and considered amendments to remove the discretion that electors had. Congressman Thomas Hart Benton, every single year for 20 years, introduced the same amendment because he said it would produce a disaster if an elector finally cast a vote contrary to his pledge and flipped the result of the election. So the presumption going in among most historians and most who had studied this case was that in fact electors had this freedom. But the reality going into this election is that everybody was terrified of the idea that an elector might flip allegiance or be induced to flip allegiance and actually flip the results of the presidential election. That this was one layer of uncertainty too far, and that we already had too many questions we were going to be facing, and those many, many questions are already occupying the attention of many lawyers around the country as we worry about the question President has suggested of canceling elections or canceling the results of elections and just selecting electors directly, or the dynamic of the blue shift, where we know that most of the Democratic votes are going to come in after in the mail-in ballots, and that's going to cause a shift towards the Democrats that the Republicans will resist, or the question of whether Mike Pence has the power, as Bruce Ackerman has suggested he does, to select which slate of electors from a particular state he's going to count. And that power can't be overridden by anybody, and so he could count himself into the vice presidency or into the presidency again. Those questions are already terrifying enough. And the question that I think that was occupying every single one of those justices is, should they add this additional question too? Now, I think that the legal analysis that my friend Justice Kagan gave to reach the conclusion that electors don't have this freedom is not going to turn out to be her most powerful opinion. That in the dissent of Justice Thomas to that opinion, there is the element that unravels her own reasoning. So not the dissent, the concurrence. Justice Kagan wrote for 7 justices. And her basic point was that there's nothing wrong with controlling an elector, constraining an elector, and that states, because they have the power to appoint electors, have the power to control how electors vote. And Justice Thomas in his concurrence said, well, if states have the power to control how electors vote, that's because states have that power through the clause that says the states get to select the manner by which electors are chosen. And Justice Thomas said, we've already said in Article 1 that the word manner does not give the states the right to control anything about how people can vote. And so that can't be the case in Article 2 either. It can't be that Article 2 gives the states the power to control through this manner the way that electors may vote. And so he rejected the core constitutional argument that the majority makes because he believed it was necessary to read the word manner the same between Article 1 and Article 2. But the problem with that reasoning is, okay, well, what about reading the word elector the same between Article 1 and Article 2? And if you believe electors can be controlled by law from Article 2, do you believe that electors can be controlled by law in Article 1? Could you imagine the state of Massachusetts passing a law that says when you vote for Congress, you got to vote for a Democrat? I mean, we already do mainly, but can you imagine what the reaction would be if we said it's an elector like a presidential elector, the state can direct them how to vote, and here's how they must vote. So the point is, Thomas submerged the question of the textual equality between elector in Article 1 and Article 2, though he relied on the textual equality between manner in Article 1 and Article 2. And because he could ignore that difference, he then concluded that the 10th Amendment preserved to the states the right to control how electors may vote, of course, not confronting the fact that no state in the history of the Union has ever, through law, tried to control how a voter may vote. So in the end, my position going into this case was a little bit hedged, right? I took this case on originally because I thought, regardless of how it gets resolved, it's important that it gets resolved before the election. So we teed up this case in a case from Colorado because we wanted to give the court the chance to answer this question before it would decide a real controversy picking who the president would be, because we thought it would be a disaster for the court to have to make that decision in the context of an actual presidential context. And we achieved that result. And however it's decided, at least now it's decided. And I think that though we also are involved in a process to think about whether we should reform the Electoral College, and we thought that if the court decided with us, there would be a lot of energy in favor of reforming the Electoral College because of this fear about electors. Even the way the court decided it, there's still tons of energy focused on how to reform the Electoral College because, as the Boston Globe put it, the Supreme Court makes it official. The Electoral College is an anachronism because what are the electors if they're nothing more than the puppets that the state may control? So this may have been the decision that had to be decided by this court in the middle of this 2020 election cycle, and there was no choice to go any other way. But I can't bring myself yet to believe that it was a decision that accords with the text or original meaning of the Constitution that we are charged as lawyers and as law professors to interpret. Thank you.
Thank you very much. I have several questions, so I'll wait to the Q&A portion to dig in with our next panelist is Thomas Mew. He's an attorney with Atlanta-based. Well, let me make sure that I'm. Excuse me. Oh, pardon. I do see that I've got audio. I apologize on that. So, Mr. Mew, pardon. He's an attorney with Buckley Beal, where he works on a broad range of employment law matters. He's represented clients at all levels in state and federal courts, including the United States Supreme Court, where he successfully argued the Bostock versus Clayton County case, which he will discuss today. Mr. Mew is a magna cum laude graduate of the University of Georgia School of Law. We both had the same amazing employment law professor, Rebecca Hanner-White, who we both think the world of. And he was also a member of the school's national championship winning moot court team. Following law school, he clerked for Judge Herschel Franks of the Tennessee Court of Appeals and for the Honorable Harold Murphy of the United States District Court for the Northern District of Georgia. Before joining Buckley Beal, he practiced law for many years at Rogers and Hardin LLP. Mr. Mew is a co-author of Georgia Motion Practice, a guide to civil motion practice in Georgia's trial and appellate courts, and co-author of Georgia Employment Law. Tom Mew.
Thank you so much. It is a pleasure to be here and a pleasure to be among such distinguished company. The Bostock versus Clayton County case turned the law at issue there was Title VII of the Civil Rights Act of 1964. Title VII is the primary federal anti-discrimination law that covers discrimination, or rather prohibits discrimination in the workplace for most employers as long as they meet a certain threshold number of employees, based on a number of different protected classes. These include race, religion, and of particular significance in the Bostock case, sex. So the issue in Bostock was whether Title VII's prohibition of discrimination because of, among other things, sex, also included sexual orientation. It's worth noting from a procedural standpoint that in the Bostock case, and I'll get into all this, but in the Bostock case, sexual orientation was the only issue. Gender identity was not an issue in Bostock, although ultimately it, along with its companion case, Zarda, were consolidated for purposes of the opinion with a case addressing gender identity, transgender issues, and I'll certainly address that in a bit more detail. Very briefly, in terms of facts, and I'm going to be quite circumspect and non either adversarial or argumentative here, simply because it is an ongoing case, and I want to be very careful about what I say there. But at a very high level, Mr. Bostock worked for Clayton County for about 10 years. He was the director of its CASA program, which, without going too deep in the weeds, was essentially reaching out to at-risk youth who had come into the court system. He had done that job with tremendous distinction. He had received a number of accolades and had made a number of innovations in the program. Mr. Bostock is also a gay man. And in 2013, very early in January, he joined a gay softball league, the Hotlanta Softball League. As he did, whenever he joined a new organization or met new people, he promoted the CASA program within that league. CASA thrives primarily on having a strong volunteer base for those who can be advocates for the at-risk youth. Shortly thereafter, we allege that Gerald's participation in the league and his recruitment of individuals from Atlanta and from the Atlanta gay community became the focus of unnecessary and illegal scrutiny in Clayton County. He was subjected to an audit regarding his expenses, which we contend was simply a pretext for discrimination against him based on his sexual orientation. In June of 2013, so again, a few months after joining the league and recruiting in the league, he was fired from Clayton County, the stated reason being conduct unbecoming a Clayton County employee. Mr. Bostock went through the EEOC administrative process, which is required under Title VII, and then following issuance of a right to sue from the agency, he filed suit in federal court. He actually filed suit pro se. He was representing himself, and he retained us shortly thereafter, and we entered an appearance and filed an amended complaint there. At the time the complaint was filed, there was an old Fifth Circuit case that, for reasons not worth going into in depth given our time constraints, is also considered 11th Circuit precedent that arguably supported the idea that Title VII did not outlaw or prohibit sexual orientation discrimination, but it was generally considered to be something of an open issue in the 11th Circuit. Very early on in the pendency of his case, before Clayton County even filed an answer, they moved to dismiss the case. While the case was pending and the motions were pending, the 11th Circuit decided another case, the Evans versus Georgia Regional Hospital, which ruled fairly squarely against Mr. Bostock on this issue of whether sexual orientation is encompassed within Title VII's definition of sex. And as a result, his case was dismissed very early on in the district court. Mr. Bostock, we did appeal that to the 11th Circuit. That appeal was unsuccessful. And then we applied, did our petition for certiorari to the Supreme Court. The timeline from petition to grant of cert was about a year, almost a year to the day, as I recall. We were helped during that time, or as part of that, because there was emerging among the various federal circuit courts of appeal something of a split on this particular issue. And obviously, when there is a federal statute at issue that's going to be applied across the country, a uniform interpretation is most desirable, and it is the Supreme Court's ultimate duty to deliver that if the federal circuits are in disagreement. Our case was consolidated with the case from Second Circuit, Zarda versus Altitude Express. Donald Zarda was a skydiving instructor who alleged he had been terminated because of his sexual orientation. Mr. Zarda very tragically was killed during the pendency of his case in a base jumping accident. And so his estate, primarily his sister Melissa, and his former partner carried on in his stead. When our cases were consolidated, this is, I think, important to note for reasons of approach and strategy in these cases. We obviously at Buckley Beal, myself and my former law partner Brian Sutherland, represented Mr. Bostock before the Supreme Court. Mr. Zarda's estate, more accurately, was represented by the ACLU, and so the traditional rule with the Supreme Court is one argument per side. One person is going to argue the case. Our cases were consolidated. We had a consent motion, or a joint motion, I should say, for divided argument. Both the Zarda side and the Bostock side were in agreement. The reason being that our arguments, while not divergent in terms of what we were arguing, we felt that there were some arguments in our brief that were, one would say, supplemental or complementary, and would benefit from additional oral argument on those points. That motion was denied by the Supreme Court, and so without going into details that I really should not or cannot, a decision was made that Professor Pamela Kalhan, an outstanding advocate from the Stanford Supreme Court Law Clinic, would deliver the argument in the divided cases, although Brian Sutherland and I had the distinct pleasure of being at counsel table with her during her very fine oral argument. Our argument was fairly straightforward in our briefing in Bostock, and it was simply this: that you can't discriminate against someone on the basis of his or her sexual orientation without taking that person's sex into account. At the risk of being somewhat pedantic, if an employer discriminates against a gay man, the employer is discriminating against the gay man because he is a man who is attracted to, or perhaps in a romantic relationship with, another man. And so sex is all over sexual orientation, if you will. It doesn't simply mean whether one is a man or whether one is a woman. And again, in both Zarda and Bostock, the issue was sexual orientation. There was a second or another case, the Stevens case, dealing with gender identity issue that was argued right after Bostock. Bostock was the first case of the term, and Stevens was argued right after. In fact, we sort of switched seats with their team and sat for that argument as well. And when the decision came down, all three cases were consolidated for purposes of the opinion, which is why the opinion also addresses the gender identity issue. In addition to the argument I laid out a moment ago, what I said was a fairly simple, straightforward argument, there were a couple of additional arguments we made with respect to what's called associational discrimination, as well as sex stereotype discrimination, in which an employer under sex stereotype discrimination discriminates against someone on the basis of his or her sex because that person does not conform to what the employer thinks a person of that particular sex, or how a person of that particular sex quote unquote should behave. In other words, you're a woman, but you're a little too macho. You're a little too brusque. Hey, you're a guy, but you're wearing these kind of clothes. You're doing this. That type of stereotypical or that type of sex stereotyping is also prohibited. And our argument was, of course, this is just another form of sex stereotyping, and any attempt to draw a line or divide the two is tenuous at best and results in things such as trying to count or parse the type of slurs in a case, the nature of the slurs, things that really obscure the ultimate analysis of whether discrimination took place. The other side, we also felt, I should say, that our argument had the benefit of being the most straightforward and the most grounded in the plain text of the statute. There was some discussion earlier, and I'm sure there'll be more, about the composition of the court. And we knew, of course, that we had to at least get 5 if we were to prevail. And we did feel that the argument we were advancing was most consistent with the plain text of the statute, as well as some subsequent Supreme Court cases, including a very important decision authored by Justice Scalia on the interpretation of Title VII and the meaning of sex. And we felt that that was the most straightforward way, and also had the benefit of actually believing that that was, in fact, the correct argument to be making. Without paying short shrift to the other side, I'll be brief. Part of their argument was that, look, whatever Congress meant when it passed this law in 1964, whatever it meant by sex, it couldn't have meant sexual orientation. Nobody was thinking about that at the time, or if they were, it wasn't something that they meant to prohibit. And our argument, again, quoting from Justice Scalia, was, well, look, it's ultimately the provisions of our laws by which we're governed rather than the principal concerns of the legislators at the time they were drafted. If the language covers the situation, then it covers the situation, and we don't need to go through this other exercise. It's there. It's what it means. Let's go. We win, was essentially our argument on that. It was interesting, simply just and I'll just note this briefly. The other argument that was advanced by the other side was essentially that when an employer discriminates against someone on the basis of sexual orientation, that employer isn't really discriminating against someone based on his or her sex, because the employer might be just saying, I don't want any gay or lesbian people working here for me. And so you haven't discriminated against men or women. You're the, quote unquote, equal opportunity discriminator or offender, and therefore it's not prohibited. I've oversimplified that argument a bit, but one can certainly look at that in the briefs and read the nuances of that. Our approach was simply to say, first of all, you can't cure discrimination by doubling down on it. Right. That's a similar argument was made with respect to laws against, for example, interracial marriage. Again, that's a constitutional context, not a Title VII context. But again, you don't simply cure discrimination by broadening its scope. Second, and more pertinent to the argument with respect to Title VII, is that there are a number of cases that make it very clear that Title VII's focus is on the individual, not the group as a whole. So in other words, there have been some seminal cases in Title VII where a employer's policy might discriminate against a subset of women, but not the entire group of women as a whole. They might not all be subject to that policy, but that doesn't mean nonetheless that the policy is not discriminatory. So that was essentially our response back to that. When the opinion came down, the court, as noted, that this was during the COVID period, and which we're still in, and decisions were not being read from the bench at that time. They were simply being released electronically. As you can imagine, on every opinion release day or potential day, I was sitting there at my computer hitting refresh like a madman. When the opinion came out, it was fairly lengthy. The majority opinion itself by Justice Gorsuch is not particularly lengthy, but there were two dissents, and Justice Alito's dissent also had some attachments. and it made the overall document quite big. It was a PDF, and it was causing the server, I believe, at the court to crash. So I had a hard time, first of all, even being able to read what the opinion said. So on pins and needles, I'm waiting for it to sort of reveal line by line what the first page says, and I was at least able to get the summary and realize that it had gone our way, and was able to just to speak with Mr. Bostock. And again, there are probably very few conversations that one ever has that are more pleasant than that, than to be able to share that with your client after what he's been through. And again, important to note that the case is ongoing, remanded back to district court, and we will be essentially starting from scratch, conducting discovery, taking depositions, and going forward from there. So while it remains a tremendous honor to represent Gerald, and it was certainly a tremendous honor to appear before the court and take part and play a role in such an important decision for so many. There's much work to be done on the individual side, and we certainly don't shy away from that. We very much look forward to doing that. I'm running a little long, but I'd be remiss if I want to share one anecdote about Justice Ginsburg during that argument, and that was simply this. She was, at that time, she was obviously never an imposing person physically in terms of stature, mentally, of course, intellectually, she was an absolute juggernaut. But it was apparent that she was somewhat fragile in her appearance and perhaps in her health at that time. And she needed some assistance exiting the courtroom after arguments. And it was Chief Justice Roberts was one of the key individuals who provided her with that assistance in a very, you could really see the collegiality there. You could see the friendship there, and you could see what I think, to follow up on the earlier point about Justice Roberts, Chief Justice Roberts, sort of reaching across, not the aisle, but maybe across divides on the bench. I just found that a very telling moment, and somewhat consistent with her well-documented friendship with Justice Scalia as well. So again, a very personal anecdote, but one that was quite touching to see in the courtroom. So with that, I will pass to our next distinguished panelist, and again, happy to engage in any Q&A later, but thank you so much for giving me the opportunity to be part of this.
Thank you so much for joining us and for sharing that story and sharing your journey with Bostock. And I know it continues, and we look forward to asking a few questions regarding that case. Our final panelist this evening, Anil Kalhan, is a professor of law at Drexel University, Thomas R. Kline School of Law. He is currently a visiting scholar at the Center for the Study of Law and Society at the University of California, Berkeley School of Law, where he also was in residence in 2015 and 2017. Professor Kalhan's scholarly and teaching interests lie in the areas of immigration law, U.S. and comparative constitutional law, international human rights law, privacy and surveillance, criminal law, and law and South Asian studies. Quite a range. He previously worked as a litigation associate at Cleary, Gottlieb, Steen, and Hamilton, where he also served as co-coordinator of the firm's immigration and international human rights pro bono practice group, and with the ACLU's Immigrants' Rights Project in New York. He also served as law clerk to the Honorable Chester Straub of the United States Court of Appeals for the Second Circuit and the Honorable Gerard Lynch in the Southern District of New York. Professor Kalhan holds a Juris Doctorate from Yale Law School and MPPM, I believe this is Master's in Public Policy and Management from the Yale School of Management, and he got his undergrad at Brown University. Professor Kalhan.
Great, thanks so much. It's really a pleasure to be part of this event. So I'm going to talk about principally about the case invalidating the Trump presidency's rescission of DACA, the Obama administration's Deferred Action for Childhood Arrivals program. This term was a very consequential and significant one for immigration law and immigrants' rights. But interestingly enough, I don't know that the DACA case is the one that will have the most lasting impact in that particular respect. But this was an unusually active term for immigration and immigration law and immigrants' rights, there were something like 7 or 8 major cases in which the court granted certiorari and issued decisions after full briefing and argument on the merits. There was another series of consequential cases that were decided on the court's so-called shadow docket, which is not within the statistics that Professor El-Jourbagy gave at the beginning of the panel, but this is a range of different orders and summary decisions that fall outside of that set of normal processes by which the court normally reviews in a full way lower court cases. These are decisions that are made often without full argument or full explanation, sometimes even without notice that the decisions are coming, like the way that politicians sometimes release news that they don't want to get a lot of attention on Friday nights. Some of these decisions come on Friday nights. And during the past year, some of them involved very significant immigration cases in which the court reached outcomes that the Trump presidency was seeking in some of its high-profile immigration initiatives. So I'm going to talk about the DACA cases, which I know got a lot of attention and folks are justifiably very interested in. It in some ways illustrates the point about Chief Justice Roberts and his potential concern for the legitimacy of the Supreme Court as an institution. But there are ways in which it also reveals maybe sort of a darker side of that approach to judging, and time permitting, and maybe we can also talk about the ways in which some of these other cases may be more ultimately consequential, because I think if you just focus on the DACA case, you might be getting a misleading picture of that. But there's obviously too much to talk about. So what is DACA? Let's start there, right? So if most of you are familiar with DACA, but just to make sure everyone's on the same page, the Deferred Action for Childhood Arrivals program was instituted by the Obama administration as a way of providing discretionary, I wouldn't even really call it relief from removal. It was more of a tenuous kind of benefit. What it was deferred action is a mechanism by which the immigration agency exercises prosecutorial discretion not to go forward with seeking deportation of people. It's existed for many years. It doesn't provide legal immigration status as such. It doesn't provide a very broad range of benefits. The government can revoke it at any time. And really, it's just this discretionary mechanism. And, one expert has described it that, well, if there are more people that can be deported than under the law, then in fact actually can be pursued by the agency, given its resource limitations. There may be some cases that have humanitarian benefit, and the agency has always exercised discretion not to go forward. And what DACA did was it sort of regularized the process by which the agency was exercising discretion and set up criteria and a way in which it was actually doing that in a more affirmative way. And it became controversial. But when the Trump presidency came to office, they didn't, in fact, actually end it right away. And in part, I think that's because, they had obviously this very aggressive immigration agenda, but the beneficiaries of DACA were people who had come to the United States as children, and had known most of their lives in the United States. So this was a particularly sympathetic population of people. And so the Trump presidency held off, and they were sort of, in negotiations to potentially get Congress to create some sort of legalization mechanism in exchange for a broader crackdown on other categories of immigrants. And some Republican officials in a number of states were getting antsy about this because what they really wanted was to see this program end. So in September 2017, at the following threats by these Republican officials in a number of states several months earlier that they would sue the federal government if it didn't end DACA by that date, the Trump administration ended the program. And there were two steps to how it did it. First, the Attorney General issued a memo stating that it was his conclusion that the program was illegal and unconstitutional. And then the DHS secretary said, on the basis of the Attorney General's conclusion, I'm going to wind it down. And then there were a number of lawsuits that quickly followed. None of them claimed that the executive branch was legally required to create DACA in the first place or even maintain it. Rather, they offered narrower arguments as to why this particular decision to end DACA was unlawful. And the principal claim was a procedural claim that DACA that the reason given for the termination, that it was in fact not a lawful program, was not in fact a permissible reason. The main reason that the argument there being that the plaintiffs in this litigation believed that it was perfectly within the discretion of the Obama administration and legal for them to institute this program. Now, in some of the other cases in the lower courts, there were plaintiffs who also argued that the decision to terminate DACA violated equal protection principles because it was motivated by racial animus and had disparate impacts on Latinos, especially Mexicans. And in support of that claim of discriminatory purpose, the plaintiffs pointed to racist and xenophobic statements by President Trump, both during the campaign and after assuming office as president, which I assume many of you may be familiar because they were widely covered. So you had two district courts issue nationwide preliminary injunctions blocking the termination of DACA based on a conclusion that the plaintiffs were likely to succeed on the merits. And then in a third case, the district court concluded that the statements that were given by the agency, by Secretary Elaine Duke to terminate the program were not sufficient to explain the change in the agency's view as to whether DACA was lawful. Because before Donald Trump became president, the conclusion was that it was lawful. There was, in fact, even an Office of Legal Counsel memo to this effect. And so the district court concluded that wasn't a sufficient permissible basis to terminate the program, but then gave the DHS an opportunity to make a new decision rescinding DACA within 30 days. So what happens then? Elaine Duke's successor as DHS Secretary, Kirstjen Nielsen, decided not to do that. She didn't issue a new decision terminating DACA. What she did instead was issue a memorandum that purported to just elaborate on the original reasons for the rescission. And the district court concluded that this was not good enough either, which created a problem that ultimately led to the Supreme Court affirming the district court's conclusion that this did not rest on a permissible reason. And I think it's a little bit technical, but can boil down to this. The government was arguing, the Trump administration was arguing that the Trump administration, the decision to rescind DACA was a valid exercise of discretion to set its own enforcement policies, right? The Obama administration had claimed discretion to do so, and we are claiming discretion. Nobody's claiming that this was required. And therefore, it was either legally permissible or just not subject to judicial review at all. However, right, when Secretary Duke issued her decision, she didn't make it as a discretionary decision based on enforcement policy grounds. She made a decision based on Attorney General Sessions' conclusion that it was unlawful. So, and in their public statements, the Trump administration, a wide range of administration officials had repeatedly insisted that they were rescinding DACA because they believed it to be illegal, not for reasons of enforcement policy. So this led to, in a way that's somewhat similar to the census citizenship question that was discussed at the outset of the panel, that really you have to in fact give genuine and legitimate and acceptable reasons to terminate to make this decision, and you can't then sort of in a post hoc way rationalize it. Chief Justice Roberts emphasized that an agency has to defend its actions based on the reasons it gave when it acted. You can't this is not a case for cutting corners to allow DHS to rely on reasons that weren't part of the original decision. So one of the things that's interesting here is to think about is why the Trump administration avoided directly stating that it was seeking to end DACA for policy reasons, and instead to insist so firmly that its decision was to rescind DACA rested on legal grounds. and then not to actually take the invitation when invited to in fact actually do so, to again not do so. And I think it has to do with the optics, that the Trump administration didn't really want to be in the position of taking responsibility for saying, yes, this is a group of people who we think should be deported. So in the process of avoiding actually coming out and saying that, I think they walked into trouble with Chief Justice Roberts and the four justices who joined him from the left, right? So Justice Ginsburg, Breyer, Sotomayor, and Kagan. Now, for his part, Chief Justice Roberts also avoided addressing directly the question of DACA's legality, because in the lower courts, the courts had said affirmatively that the part of the reason why this is not a valid reason to terminate DACA is that DACA was in fact permissible. It was not, the agency's actions was based on a misconception that DACA was unlawful. And in his opinion, Chief Justice Roberts doesn't really say that. He instead said, proceeded in a more subtle way to suggest that there may in fact actually, that the Homeland Security Secretary was bound by the Attorney General's legal determination and could not make an independent legal determination of her own. But of course, the Supreme Court was not bound by that legal conclusion. So it was a little bit of a deflection on his part too, which is interesting to think about. And in his dissenting opinion, Justice Thomas pushes very hard on this, and in another separate dissent, Justice Alito as well, really concluding or calling out Chief Justice Roberts for making a decision avoiding making a decision that the law, in their view, required in order to avoid, similarly, the optics of in public opinion, and sort of calling out the emphasis indirectly on the court's legitimacy, which is nowhere stated really, but that's, I think, the subtext of the critique. So why am I saying this is not quite as consequential as perhaps some of the other decisions? So for one thing, because what was at stake was how the program has ended and not whether it could ultimately be ended at all, there really is a roadmap here for how the Trump administration could go about ending DACA. And they have, in fact, now proceeded on that basis to issue a new memorandum, more directly taking ownership of the policy reasons for why they think that DACA should not be in place as a matter of policy, not really backing off from their claim that the Obama administration were lawless and just ignoring the law, but not resting on that in the same way. And so that process is in motion. Of course, what the ultimate fate of DACA will be depends on what the election results will be. A Biden administration almost certainly will reinstate DACA with a view towards seeking legislation that would lead to the kind of more durable solution that DACA beneficiaries and other undocumented immigrants really want. But if the Trump administration does have a second term, I would imagine that they will proceed more aggressively towards ending this program. The other, so that's one piece of this. The other thing that has been suggested about this opinion by Chief Justice Roberts is there might also be elements that critics of an incoming Biden administration might draw upon when they are seeking to stop if the Biden administration wants to, for example, reverse some policies that have been instituted under this presidency, if they do not cross their T's and dot their I's scrupulously, there are ways in which this kind of holding might also provide a roadmap for folks who are trying to prevent the Biden administration from shifting directions in immigration policy, but potentially even in other areas. So I've gone on for a while, so I do want to stop there, but I do want to, so I'll just sort of flag that some of those other decisions, that one in particular, DHS versus Thurasingam, is one that actually has the potential for having some very lasting effects on the rights of non-citizens within the United States, insofar as it cuts back on due process for non-citizens within the United States. And I think it's one to watch, that folks should be aware of and should think about and watch, as to how broadly the lower courts, and if it comes back to the Supreme Court, it is read. And that is certainly a case when Chief Justice Roberts was in the majority, and in fact all of the other cases involving immigration that were less protective of immigrants' rights in the way that the DACA case was, Chief Justice Roberts was fully on board with those cases, even if not writing the opinions in them. So I'll stop there, and I look forward to thoughts that folks and questions that folks might have.
Thanks to all the panelists. They've all graciously agreed to answer questions from our attendees this evening. It's been up to about 145. We have several questions out there, and I'm going to pass the program over to Professor of Political Science, Dr. Elliott-Gower, to facilitate that.
Thank you, Jehan. Thank you, panelists, for a terrific discussion so far. We have a number of questions that have come in on the chat. And our first question is a general question about the Supreme Court. And Professor Lessig, I'd like to address this question to you. And it's, why are justices not limited on how many years they can serve?
Sorry, Professor Lessig, would you start over? Okay, that's okay.
The framers were obsessed with how to establish the right kind of independence for both the presidents, for Congress, and for the judges. And the anxiety they had is that the judges would, if they were dependent on Congress or anything, be unresponsive to the rule of law. So their innovation was to say judges would serve for life tenure because they would serve for as long as they satisfied the good behavior standard, and that turns out to be for as long as they want to serve. But there's no good reason for it. There's no good reason to have life tenure over, for example, the way the Germans do it, or most constitutional courts do it, for a limited term. And I think there's a big movement now to think about whether there could be a limited term. Now, one requirement if you wanted to change the Constitution, that's obviously very difficult, given the amendment requires 3/4 of the states to agree, and it's hard to get the energy to do something like changing the Supreme Court's policy there. But, people have noted Congress could have the power to say to Supreme Court justices, you're going to serve on the Supreme Court for 15 years, and then you're going to go serve as a Court of Appeals judge, or go serve on a Court of Appeals. Or, they have used the retirement incentives of, various kind of retirement packages as a way to induce them to step down. And I think that those might be actually something that you begin to see the next administration experimenting with. But I think we all should embrace a point which I think this recent passing has demonstrated. I'm not sure why justices think that they should spend their last waking moments in life serving as a Supreme Court justice. I mean, Justice Souter, I think, was quite admirable in deciding at a certain point that he had served his time and it was time to move on. And I think that if that norm were to develop and we could have more regular turnover, maybe with even a bigger bench, there would be less political reckoning for each of these new justices who would come along.
Right. And I guess if popes do it, that is retire, albeit only twice, then maybe Supreme Court justices should as well. Our next question, that first question was from Garrett. Our next question, I actually had two questions that were very similar from Caroline and Hayden. So I'm going to kind of combine here. And these are questions, I think, for Professor Roessing. And the question is it likely that a new justice will be appointed or should be appointed to Ruth Bader Ginsburg's seat before the coming election? Matt?
Okay, as to whether a new justice, well, certainly a new justice will be nominated. Trump has said that he plans to nominate a new justice on Saturday. One of the big questions is whether that justice will be confirmed, A, before the election, and B, before, assuming if Biden wins the election, before Trump leaves office. I think that, yes, a Trump nominee will be confirmed by this Republican-led Senate. Whether that happens before the election or after is mostly a question of timing. They're pushing very hard to try and get the confirmation done before the election. It's going to be very fast. It may not happen. Should they do that? Well, this is a matter of opinion. This is the big question. In fact, it's the question that I posed to my students in class today. And here's how much my opinion on this matters. Absolutely none. The only people whose opinions matter on this are the Republican senators, and particularly the Republican senators who are facing their own election in November and that have to answer to a bipartisan electorate. Particularly senators in what we call purple states that have to get some Democratic votes to win. So everybody's been looking at them. Two of them have come out and said, no, let's wait. Mitt Romney, who is not up for re-election, but thought to be possible a third vote, has said, I'm comfortable moving forward. Hasn't said whether he'll vote up or down, but he will vote. So the chances of pushing this back to a Biden inauguration, I think, are slim to none.
Yeah, and I heard just this morning that the average time that it has taken to nominate a Supreme Court justice is 69 days. That's the average, and I think we'll be under 40 days or at about 40 days on Saturday. Hunter has a question for Mr. Mew. The question is, when did sex stereotyping become prevalent in our society, and how often do cases like this come up? Mr. Mew?
Sure. Well, and at the risk of being, I'm not trying to be cute or flippant. I think sex stereotyping has been prevalent in our society for a very long time. But in terms of more directly addressing the question in terms of an actionable legal event, the seminal case on this is probably Price Waterhouse versus Hopkins, which was argued in 88, I believe, and decided in 89. And that case is a bit of a difficult read because it is a plurality opinion on a couple of issues. One, which we need not get into, is mixed motive standard. And the other addresses more squarely the sex stereotyping issue. But because it's a plurality opinion, one kind of has to cobble together where one can. But that was the seminal case on it. The woman in that case, Ann Hopkins, was denied a partnership with Price Waterhouse. There were comments made with respect to her being, and I'm not going to get the exact verbiage of the comments, but being too macho, maybe not feminine enough in her appearance or manner of dress, things of that nature. And of course, when the argument being that is actionable discrimination, because if you're expecting someone to adhere to a gender norm, you're projecting upon that person stereotypical notions about how members of a particular sex should or should not behave or present themselves. So yeah, and I would also say at least in my practice, in my experience, it's typically a tag-along type claim in the sense that the primary claim is sex discrimination. However you break it down, sex stereotyping is a type of sex discrimination. So you may have a case where, for example, a woman is viewed that way, but quite often the evidence would be, or one would expect the evidence would be, there was other instances of discrimination that aren't specifically tailored along those lines. I also think that, and again, not trying to pat myself or the Bostock or Zarda teams too much on the back, but I think that as a result of the decision in Bostock, hopefully we will see less of this attempt to parse whether something is truly a sexual stereotyping case or really just a sexual orientation discrimination case in sheep's clothing, as some courts have tried to do, and hopefully we're beyond that point now.
Thank you. Please go ahead. Okay, that next question then is from Matt to Professor Roessing. So it's a Matt to Matt question. However, it's something that Professor Roessing has already addressed. So I'd invite other panelists to comment on this question. The question really concerns Chief Justice Roberts' legacy. What will his long-term impact be on the court? So Matt, would you like to just restate your opinion, and then maybe some of the other panelists will jump in?
I'll give the great lawyer's answer. It depends. And in this case, it depends on what's going to happen over the next few weeks and months. I think, as is largely expected, Trump gets a nominee approved by the Senate. Then the court shifts rightward, and Roberts is still important, but not nearly as important as he's been in that semi-swing vote capacity. However, if the electorate is so incensed by this that they rise up and vote blue for, flip the Senate, give Joe Biden the presidency, hang on to the House. Something that's been talked about is that they may end up adding justices to the Supreme Court or completely rework the federal judiciary, which they would have the legal power to do. In that case, depending on what they do, Roberts may still retain some control at the center. If Democrats add a few seats, but only a few, maybe he goes back to being the quote unquote swing vote. If they add, a lot of seats and they get away with it politically, then he may have very little role at all.
Yeah, I think it's really important to recognize that the growing sense among Democrats is that they've been rolled one time too many in a whole series of events going back to Bush v. Gore, and that there's a really strong push in the Democratic Party now to meet this next event with equal and maybe greater force. So I think many Democrats, and my own view is rightly, perceive it as outrageous that Mitch McConnell would invoke a quote unquote principle to deny Barack Obama in his literal last year of his presidency, in February of his presidency, the right to at least have his nominee considered, while at the same time accepting the idea that Donald Trump should not only have his nominee considered, but confirmed in record time. Of course, McConnell justifies his rule by saying, well, actually, there are two different circumstances. In one case, the party in power controlled the Senate. The party of the president controlled the Senate. In the other case, they didn't. But that's just to say that it's a purely partisan, purely political rule that has nothing to do with quote unquote principle at all. And I think that is going to trigger righteous indignation on the other side. And so I would predict, I think you're right that we're going to see the question of like adding more justices, but I would predict that the number they add is not 2, they add 4. It's like tit for tat. Like you behave badly, you will be severely punished for behaving badly. And if that happens, then this whole game turns out to be for naught, because that would neutralize any, shift that's achieved by, this would have been President Trump appointing a third justice, 1/3 of the existing court appointed by a man, who didn't even win a plurality. I think that sense has been lost. It will motivate Democrats in a really significant way.
I mean, he might as well have said, well, Justice Scalia died on a Saturday and Justice Ginsburg died on a Friday. The situations are completely different. I mean, I think there's also a deeper brewing legitimacy problem that has been even deeper roots. I mean, you could go back to Bush versus Gore. And so, a minority popular vote president coming to office, then having appointed 2 of the justices. I mean, the last time that there's been a majority of Democrat appointed justices on the Supreme Court, I think you have to go back to like 1969. And it's not because there have not, there's overwhelming political dominance by Republicans in the interim. There have been these kind of sort of moments of potentially one you could understand as manipulation in various ways, and then layered on top of the sort of increasing sort of other mechanisms of minority entrenchment that have been in our political process, sort of do give rise, if the public responds, to a potential looming legitimacy crisis for the court.
Our next question is from Haley, and it's for Professor Lessig. And the question is, do you think the way the election is happening this November is scary? How do you think it will be done best and fairest? And I think a lot of us can that question, I think, resonates with a lot of us, doesn't it? Professor Lessig?
Yeah, I think scary is actually a really good word for this election. The reason is, we have an incredibly fragile system for selecting the president. I basically spent the last 4 years reading every single thing there is about the Electoral College and the system for electing the president. and is really a poorly constructed system. Maybe not originally, but certainly today. And it depends on both sides engaging in good faith. And if both sides are engaging in good faith, then, in an end, you can work it out. And there have been really important moments of this. Richard Nixon in 1960 easily could have thrown the country into chaos by insisting on the corruption in Chicago and that John Kennedy should not have gotten the votes from Illinois. But he didn't. He stood down. And Al Gore, after the Supreme Court's decision in 2000, easily could have continued the fight into Congress. And indeed, he was the president of the Senate. According to Bruce Ackerman, he would have had the right to decide which electors get counted or not. So he easily could have played constitutional hardball and counted himself into the presidency, but he too stood down. And I think that's been our tradition. And what terrifies me right now is imagining an election where there isn't good faith on both sides. Like there's been a complete demonstrated willingness to throw the norms to the wind. So the latest, the Atlantic article that came out yesterday talks about the president's team floating the idea that if they can establish the credible claim that the votes in particular states are marred by voter fraud, they can convince the legislature just to appoint the electors directly. Instead of the election determining who the electors are, the legislature would. And obviously, I wouldn't oppose that in principle, assuming there was some independent determination of whether there had been voting fraud. But obviously, when you have an interested party who uses the bully pulpit of the presidency to declare there's been voting fraud in order to short circuit the election and be able to count himself into the presidency, that's a significant problem. And it is, I think, precisely scary.
Yeah. So if it wasn't Nixon, where do panelists think that this norm trampling minimal cost approach came from? What are the origins of that? Professor Lessig and then others?
I think, whether you think it's a good thing or a bad thing is a separate matter. I mean, I don't think it's a good thing, but I think this president has been a norm violator extraordinaire. There's a whole range of norms that we all thought governed the executive, but it turns out they don't. And when they don't, nobody's going to step in and do anything about it. The Supreme Court hasn't done much about it. I mean, I think John Roberts he's been masterful in certain critical cases in deploying a judgment about what preserves the institutional capacity of the court. But that same instinct has led him to shy away from a really direct confrontation with the norm violations of this president. And so if that's true, I don't see the court stepping in. And if he's willing to do whatever it takes to make sure he's reelected, then I'm not sure what will stop him.
Would others like to comment on that issue? If not, we'll move on to the next question, which is from Branson to Mr. Mew. I'm trying to understand Clayton County's argument in the case a little better. Are you saying that their argument was that they had a right to fire Mr. Bostwick because there was no law that stated it was illegal to discriminate based on sexual orientation?
Generally, yes. And let me walk that back a little bit. In the posture of a motion to dismiss, which is where his case originally went out, if you will, or where he originally lost in the trial court and where we're going back, one responds to a complaint with a motion to dismiss. One is saying essentially, assuming, because this is how the court is going to read it, assuming everything he says in the complaint is true, we still win because. So you've got to have a legal argument there, not a factual one. And so their argument there essentially was, and to be clear, they have never come out and said we discriminated against him because he's gay, but that's not against the law. That's not what the argument was. But the argument was, even if we did do that, essentially, it didn't matter because it's not illegal to do that and it doesn't violate Title VII. And therefore, under Georgia's actually statutorily entrenched at-will employment doctrine, we weren't breaking the law. So yes, that was a substantial part of their argument. There is no such law that prohibits it, and while we don't admit that we did it, even if we did, we wouldn't be breaking the law.
Okay. Another question for you, Mr. Beal, and I confess I don't really understand this question. It is from Joanna, and the question is, Fulton versus City of Philadelphia seems a much different case, more than the court composition has changed, regardless of whether presumably Ginsburg's seat is filled or not. What are your opinions of that case? So what are your opinions of Fulton versus City of Philadelphia?
And I apologize, I'm a little unclear as to what the question is asking me.
I was as well. I'm going to ask Joanna to maybe rephrase that question, and we'll come back to it. Okay.
Certainly, I'd be happy to address it. I just want to make sure I'm actually answering it if I can. Yeah,
sure. Professor Lessig, we have a question for you from. You discussed electors having these constraints of political allegiances. Do you feel electors still have these constraints today? Is this an issue that needs to be overcome? And how do you think they could be overcome?
Well, I think that it's completely appropriate that after the presidency shifted from the nonpartisan presidency of George Washington and the conception of the presidency as nonpartisan to the partisan presidency that, obviously the 12th Amendment embraces and has been the presidency ever since George Washington. I think it's completely appropriate that if we're going to have electors, that they be chosen and pledged to a particular party or to a particular person. The question is whether they should also retain a discretion, given that they have made that pledge. Now, these electors are typically called faithless electors, but it's not really a fair description, in particular, of my clients, because my clients were in Washington state, 3 electors who were pledged to Hillary Clinton. After it was clear that Hillary Clinton was not going to be president, their view was that their voters would much rather have some other Republican than Donald Trump. So what they tried to do is to recruit 37 Republican electors to join with them to vote for somebody other than Donald Trump. And they had their own particular favorite, not for the purpose of the Electoral College choosing that person as president, but for the purpose of giving Congress the chance to choose who should be president. So Donald Trump or Hillary Clinton, or let's say John Kasich. Now, nobody thought Clinton would win in that contest, even though one might say she did win the popular vote. Maybe she should have won, but that wouldn't have happened. But the point was, let's let Congress decide whether a guy who hadn't won even the plurality should be chosen as president in a contest like that. So that was not faithless. It was exercising their discretion in some sense to advance the interests of those who elected them and their party. And so the question is whether it's important to retain that kind of discretion. And our review of the history of electors is that there has only ever been one time in the history of America where an elector voted contrary to how they were pledged in a context where it could have mattered to the ultimate result. And that was the story I told you about from 1796, because 1796 was relatively close. And certainly in that case, there could have been one or two who flipped, and that would have flipped the result. But again, it would have flipped the result towards the winner of the popular vote. So these electors have not been behaving badly in our history. And it's pretty clear that the systems presumed that they had that discretion. And now the court has basically said Congress has the freedom to remove it. But we should remember, the Supreme Court has said the states have the power to remove that discretion. The vast majority of electors have discretion right now. Nobody has removed their discretion. And so, one of the questions people have raised is, well, maybe states should be passing laws telling the electors they've got to vote one way or the other. Because, we counted that the effect of this decision was to take 74 electors and say that they no longer could be bribed. Okay, but there still are a lot of other electors who are technically could be, unconstrained, and they can vote as they want. And if you are genuinely fearful of this, then maybe that's something you ought to step in and correct.
Yeah. I have a question here for Dr. Kalhan. But before I ask the question, I would just like to invite the panelists to ask questions of one another if they feel inclined after this question. So this is a question from Olivia for Dr. Kalhan, and she asks, do you believe they will be able to completely do away with DACA and deport all undocumented and illegal immigrants, considering the amount of undocumented immigrants that have been contributing to our economy since their arrival? Do you believe the US will do for those that have been in America in seeking asylum?
So I think there are two different pieces to the question to address separately. One is, can the government end DACA? And I think the answer to that is quite clearly yes. And the Trump presidency has already begun the process of winding it down. And I would fully expect that if they have a second term, that will happen. That doesn't mean that every last person who's a beneficiary of DACA would necessarily face the possibility of face deportation immediately or ever. They would be vulnerable, though. You know, they would be back to the situation that all undocumented immigrants who were before DACA, and many continue to be, where they are living in the proverbial shadows and in fear of potentially facing deportation at any time, which has very consequential impacts on people's lives. But I do think, you know, the resources that the executive branch has to pursue removal are finite. In a second term, you know, it might be the case that they're able to, that the executive branch is able to take more shortcuts on due process, take more liberties that they haven't been able to do, and that can effectuate more deportations. It may be that they get more resources from Congress, depending on what Congress looks like. I think it's probably unlikely that the House turns over, so that may not be in the cards. But I would expect a Trump presidency in a second term would aggressively seek to push the envelope on what they can do, and people will be vulnerable. And across a range of circumstances, with the caveat being that sympathetic cases that gather public sympathy are not the kinds of cases that even the most xenophobic administration necessarily wants to be making front and center the picture of what they're trying to do. Now, if the Biden administration comes into office, I think the calculus is a little bit different. I think that DACA comes back right away. But then the question becomes, you know, DACA is not an end state for people. It's, you know, forbearance in this kind of immigration purgatory. And then the real question becomes, is there in fact enough political capital and momentum and political will to have a more durable and lasting solution that creates a path to legal residence, legal status for people, and for whom, right? Who are the people that are going to be left out of that? Because when Congress has put immigration reform on the table, they've always had these carve-outs that leave people vulnerable if they have criminal convictions or what have you. So, and those carve-outs have been broad in recent proposals. So I think that's what the landscape looks like under one presidency versus the other.
Okay, thank you so much. Before we see if you have any questions for one another, I do want to go back to Joanna's question, which has been restated. And so this is for Mr. Mew. Fulton hinges on LGBTQ discrimination based on religious grounds, which seems a tougher bar than Bostock. Maybe it would be 5-4, and it's being heard in November. With RBG gone, that changes even if Trump's nominee isn't confirmed. Does that question now make sense?
It does. Yes, I understand. Yeah, I think the important thing to remember about that case is that, and the question correctly notes this nuance. It's not an employment case. What we're talking about is essentially a First Amendment issue. Well, not essentially, it is a First Amendment issue with respect to what Catholic social services, what they could do and not do in terms of their own policies with respect to placing foster children with same-sex couples, and whether the city of Philadelphia, in refusing essentially to renew a contract or otherwise do business with them in a very colloquial sense, it has somehow violated their free exercise rights, which is always, I think, when you're on a constitutional path as opposed to a statutory, an employment discrimination statute, it's always going to be a trickier and more there's such, particularly First Amendment free exercise, there's all kinds of precedential baggage already there that one has to deal with and confront, as well as something of an evolving analysis. I would say one thing that might be worth taking a look at least in terms of thinking about projections, is a case that followed not long after the Bostock decision, the Sisters of Our Lady of Guadalupe case, which also dealt again, it was dealing with religious exemptions in a context somewhat different from the city of Philadelphia case, but it might be worth a look too, as well as for one who's looking to count some tea leaves or read some tea leaves in that case.
Mm. And I do feel the need to follow up, Mr. Mew, with a question from Alison. Mm-hmm. Is there a chance that the new Supreme Court could redefine gender to assigned at birth, reversing all legal changes to date for individuals?
One, I certainly would hope not. Two, I don't believe that would be the case, simply for purposes of, and again, if we're talking about that happening, we're talking about a lot of things going out the window that are, and we may be in a gloves off, anything goes kind of territory right now, as others have very astutely said, but you would have to be showing extreme disregard for stare decisis, for prior precedent of the court, and you would have to essentially be saying square on, we were wrong here, and and you're going to get into all kinds of issues beyond Title VII if you're going to try to do that. And I think that I would view that as unlikely, but always concerning that a subsequent composition of the court could certainly undo or at least lessen the power of a decision that an advocate such as myself would view as a very favorable decision, and a very important decision for not only my client, but others I represent, and for the United States as a whole, for our workforce.
Yeah. Let's take just a brief pause on participant questions to see if our panelists have questions for one another.
Lawrence, I'd be curious about the dynamic of the telephone argument, a little bit more about that.
Yeah, so, I think I have the honor of answering the most questions from Justice Thomas of any oral advocate in the history of his time at the bench. He was quite engaged. And though I think that's a good thing, I actually think it's a pretty destructive thing that they structured it in the way that they did. And I would point to two things that I think were weakening of the process. Number one, I think the chief was too restrictive on time. It was an unfamiliar context. It's not like they've got a lot of work to do. As we see, this is the fewest number of opinions since the Civil War. So instead of an hour or 2 hours, they could have done just as long as it takes till the justices feel like they understand the issues. That's number one. And number two, as anybody who's argued before any court recognizes, that in the course of an oral argument, there's a certain life to the questions, they evolve in a certain way. And the problem with justices coming in with a list of questions that they've been given by, with their clerks come up with, is that they're not so much listening to what the conversation has been, they're just trying to get their questions in. And so I often found that they were disjointed conversations where it was did you hear what we just said back there? Because that's basically exactly what you're asking here. And so I think it changes the way that the arc of an argument develops. With an ordinary Supreme Court argument, questions get framed very early by justices talking to each other. And then over the course of the argument, the justices kind of work it out among each other in the source of those questions. And that couldn't really happen in this type of context. So I think it was, the right thing to do these by telephone, but I think it's vastly inferior to what it could be if it were a regular oral argument.
So I have a question for any of my fellow panelists. much of the discussion, at least in the last week, in terms of what kinds of responses we might see to question, a sense of a mismatch between the legitimacy of the court and where the public is, have focused on numbers of justices. And I would be interested in what folks think about other kinds of proposals to change the jurisdiction of the court, whether by expanding its mandatory jurisdiction, speaking of they aren't doing a lot of work, and making more cases that they must hear, or by withdrawing jurisdiction, because I think I've seen proposals to both effect, but they haven't actually been that prominent in the conversation, at least so far.
Okay, any other questions from the panelists to the panelists? We've got about 10 minutes left, and there are a couple of big questions which I would invite all of the panelists or several of the panelists to address. One question, I've lost it now. I can't remember. Well, the question was, I can't see who it was from, but the question was, is court packing a good idea? Presumably from the Democratic perspective. Professor Roessing, would you like to address that one first? Court packing.
Sure. I think like a lot of these questions, it depends on who's packing the court and whether you agree with their politics. Is it going to destroy our democracy if we add seats to the Supreme Court? No. The number 9 is not set in stone. I think they started out with 6, that then rose to 10, that got cut down to 9. It would seem very weird to those of us who are used to 9 as tradition. But I don't think it would completely change things. As certainly the panelists know, and as a lot of people probably know, FDR proposed this when he had a conservative court that was striking down all of his New Deal legislation. And, he might have gotten away with it had he been a little more conservative, so to speak, in what he tried to do. There's a sense that, the Senate at the time may have given him 2 justices, but he wanted, 6. He wanted an overwhelming, basically a rubber stamp. And that made, the senators uncomfortable. Also, the court kind of maybe corrected itself, and it became politically unpopular. So I think it really depends on how it's done. Professor Lessig talked about this. Do the Democrats put in 2 to represent the stolen seats, or do they go for 4? Or do they go for 40? I mean, anything, the sky's the limit on what you can do. It's just that at what point the public starts to think this is ridiculous.
I just want to say, I think it's really important to distinguish the reason that the packing is happening. So I think FDR's packing was a bad thing because he was packing in response to the Supreme Court's decisions. He didn't like the Supreme Court's interpretation of the Constitution. And whether he was right or wrong, the idea that the president through Congress would try to amend the Constitution by packing the court is, I think, troubling for lots of reasons. But I think if the Democrats were responding to bad behavior by the Republicans as a way to kind of set or to enforce a norm that ought to exist in the context of Congress, then it could be a precedent that actually helps the process of how things happen in Congress. And so I think it needs to focus not so much on the fact that there are a bunch of conservatives, which of course there is, but on the fact that this norm violation by the Senate, by Mitch McConnell, makes it, is incredibly destabilizing to the process of normal government.
Given the current divisive political climate, do you think that court packing is a very dangerous precedent? That is, the next time we have a Republican president, Republican Senate.
I'm almost afraid that the norms have been shattered to the point where right now the party in power, if they can do it, they will do it. And we're seeing that with what, quote unquote, the nuclear options, where first the Democratic Senate reduced the votes from 60 to 51 for lower court judges. Then, McConnell did it for upper court judges. It's almost like you're going to do it now just because if you don't, you wasted the opportunity, and the other side's going to do it when they get into power. And it's sad, it's troubling, but it relies upon, to fix it, we need whatever party gains significant power to use that power to limit it rather than expand it. And I think we all agree that would happen, but nobody wants to jump first.
Yeah, I probably have the most sort of layperson's view of this in a way, given the distinguished academic credentials of the other folks. But I would say that a lot of it, of course, comes down to what is the public confidence in the judiciary, and do we view it as some type of independent branch, albeit with appointments and even elections being inherently a political process, or do we view it as simply being a tool of whatever the majority party is at the time to effectively, if not a legislative veto, because we know that doesn't work, but on the court, but essentially something along those lines of attempting to basically just say, well, we're going to form you in our image, if you will, and go that way. I understand, of course, the concern with that folks would have right now about the integrity of the process in general, with respect to obviously the hot button issue going on right now with the appointment. But I do have an overriding concern with public confidence being eroded further and further. And I think you're absolutely right. If somebody doesn't step up and draw some kind of line on this and say, just because you can doesn't mean you should.
Yeah. I'd like to ask a brief question, kind of circle back to Mew. You mentioned how Roberts was assisting Ginsburg as she left her seat. And Professor Lessig, I'd heard in an interview that you did that you had actually clerked for Scalia, and that that you were considered a liberal clerk for him, and he decided to no longer hire liberal clerks. So my Constitution Week, part of this entire endeavor for Georgia College is to have respectful discourse, to address issues that we hear both sides and that people have an intellectual discussion. And so to the panelists, how can we go forward? What do you think the landscape should look like?
Well, I mean, let me start on that. I think we're in a really critical constitutional crisis, and I don't mean the United States Constitution. I mean a democratic constitution. I mean the constitution of our democracy, because we live within an environment where we are pushed into these tribal polarized corners. The media, the infrastructure of media, the business model of media profits the more they make us into crazy partisans. They depend on us being crazy partisans. That's true of cable television. It's true of Facebook. And so long as we live in this world where they make money, the more they make us look crazy, we're going to be crazy, and we're going to feed into this polarized fury that happens in Washington too. And so I think the thing that I'm most afraid of is that we evolve into this place where you always have your base media that tells you what you want to hear, and you don't have to listen to the other side anymore because you can survive on the basis of your base alone. And that's not how you run a democracy. A democracy is about learning to work with people who you disagree with and come to a common agreement, recognizing that disagreement. And that means compromising and coming to understandings that might be different from your first best or your first preference. But there doesn't seem to be any need for that in Washington, because to do that is to play against this basic infrastructure of incentives. And it terrifies me. I don't know how we get away from that, because obviously you can't regulate against that. And it's not clear what other model can compete successfully against it.
The court packing question, by the way, was from Ainsley. And the last question and comment kind of get to, well, not kind of, they do get to Sophia's question about the future of democracy. And the final question in the last 2 minutes is, do you feel that our status as a democracy is under threat? And maybe could we begin with you, Professor Kalhan?
Sure. I share the concerns that Professor Lessig just articulated, and I would add to those, I think that there's plenty to add. I'll just pick one thing to add. That the last 4 years have, for me, given rise to a real concern about the strength of the rule of law. And what I mean by that is the notion that, just sort of classic rule of law values of even-handedness of law, very basic, right? In the sense that we have this, very aggressive discourse about law and order from an administration that is disregarding law all the time. What that says to me is that we might have this kind of duality where there's one set of rules that elites are expecting other people to adhere to when they're not prepared to do that for themselves. And I think if we go far down that road, that is terrible for democracy. It is terrible for, for a lot of things that we care about as a society and have long upheld and fulfilled and promoted around the world.
Yeah. Others on that question? In that case, let me thank our panelists for their learned analysis and comments on these issues. Let me thank the participants, our students, for their terrific questions. And with that, I'll hand it over to my colleague to conclude the program.
Panelists, we certainly appreciate your time. Thank you so much for spending it with us virtually at Georgia College. I thank you again, and to everyone out there, thank you for spending 2 hours with us discussing the Supreme Court, and wish you all well.
Thank you so much.
Thank you.
Great pleasure. Thank you.